ABDULAI had argued the court's March 9 judgment ignored legislative antecedents of the voting history of deputy speakers in Ghana. He added that failure of the ordinary bench to consider portions of Ghana's constitution and the Parliament Act of 1965 meant the court got it wrong. Deputy Attorney General Diana Sunaba Dapa disagreed. She insisted the review threshold had not been met, a position the court upheld, dismissing the application for review. The Deputy AG is not surprised.
The review application is very strict and the grounds clearly stated, and one needs to find his case within the threshold set for a review application, that exceptional circumstances which has occasioned a grave miscarriage of justice, and there are new information that has been discovered which was not present at the time of the determination. I do not think, even without going through the review application, any argument advanced by the plaintiff on the basis that the court ought to have had regard to previous constitutions and other statutes of the Commonwealth will still have held. As you clearly heard, our constitution, which is a written one, is sui generis and ought to be interpreted in accordance with its peculiar nature. And so reference to other constitutions, even previous constitution, is no basis.
Mr. ABDULAI says the odds were up against him.
Prior to today, I had made it clear that a review application is probably one of the most difficult things to succeed in at the Supreme Court. And so I knew the odds were against me. Indeed, some had predicted 1:100. I had predicted almost 0. Except that I still moved forward with this because, in principle, as I said, I believe that the Supreme Court is made of seasoned lawyers, and if you make strong arguments before them, they were amenable to reviewing their decisions, their previous decisions. As it turns out, they decided otherwise. And once they've decided otherwise, I think we have to move on as a nation. What I didn't want was a situation where posterity would question us.
This brings an end to the dispute over the voting rights of a deputy speaker. For Joy News from the Supreme Court, my name is Joseph Akablay.
And that is the premise for the commencement of our big stories. In fact, the very first one we're starting with, the Justice ABDULAI petition at the Apex Court. And the Supreme Court, in a unanimous 9-0 decision, has dismissed the review application put forward by Justice ABDULAI. Like you heard him say, he gave himself even less than 1 out of 100. But here we find ourselves, we're going to be interacting with the man who put forward this petition. Justice ABDULAI joins us on this story. Later on the big stories, we'll also be looking at the James Gyakye Quayson scenario and how things are going to pan out. He wants that injunction removed in terms of his performance of his duties as a member of parliament. And he also wants the substantive case at the Apex Court dismissed. But let's start with Justice ABDULAI. A very good morning to you, sir. You may have to unmute Justice ABDULAI so I can hear you. All right, so we shall get to Justice ABDULAI as and when it is possible to do so. He'll be joining the conversation. We'll also have other lawyers like Bobby Banson, Inusaf Hussaini, former member of parliament, and also a member of the legal team of the NDC joining the conversation as we walk through the issues. But let me, before I get to the man who was in court on the matter, let me get to Bobby Banson. Bobby, a very good morning to you. Thank you for joining us on the AM show.
Good morning, and thank you for having me.
All right. It's always a pleasure. Any surprises in there as far as what transpired in court? Justice ABDULAI himself says, well, people were saying he stood at 1 out of 100 chance. He himself felt he stood even less than 1% of a chance. And another unanimous decision by the court, this time 9-0. What do you make of this entire exercise, and were you surprised?
Well, I at least Justice himself said he was not surprised. It's not because we don't think that he made a good case or made arguments, but just that the practice of law is in such a way that it's governed by rules and procedure. And so if the jurisdiction of the court to review, the Supreme Court to review its own jurisdiction, its own decision, can only be invoked on certain grounds. And when you are faced with the facts, you know that you will not be able to demonstrate those grounds, then you know for a fact that you will not succeed. So, but I'm happy, at least he said for posterity's sake, he wanted his mind to be at ease, or his conscience to be at peace, that he exhausted all possible legal avenues to ventilate his grievance. And so we will not fault him for that, except that he knew what the outcome most likely to be. And we will just, like he said, we will just take it in our strides and then move on with it.
When you look at the decision, and just to look at a bit here, Justice ABDULAI said that after the delivery of the court's decision, that he had discovered new and important matters or evidence which, after the exercise of due diligence, was not within the applicant's knowledge or could not be produced by him at the time when the decision was given. And when you look at what was filed in court, did you see any substantive difference that could have swayed the court in any way?
To be honest, I have not had the benefit of seeing the full review application that he filed to know exactly what new evidence, as you put it, or new facts that were not available to him at the time he filed the writ that would have been presented to the court, and if it was, would have perhaps changed the mind of the Supreme Court. So I'll leave him to demonstrate or to show some of these facts. Then I'll be in a position to comment on the impact it would have had in the decision of the Supreme Court at first instance. Okay.
Let me also just ask you this as a practitioner before I go on to Inusa Fussaini. But let me say a very good morning to Inusa Fussaini, former member of Parliament and a legal brain within the NDC as well. Honorable Fussaini, a very good morning to you, sir.
Evans, good morning. How are you?
I am very well. Hope you are too.
Good.
I'll be coming to you shortly on your take on this matter. But Bobby, just to confirm, so we've heard from a former Justice of the Supreme Court and former President of the Ghana Bar Association, Justice Amegacha, who has revealed that 80%, a good 80% of applications put before the Supreme Court do not pull through. They fail on the basis of merit. Why do you think that is, especially as we've seen one such instance in this specific case? What is it? Is it that the Supreme Court is it poo-poos a lot of these, or that somehow a lot of what is sent to it simply is frivolous?
Ben, I would want to put the comments by the learned Supreme Court judge in context. I believe what he meant to say, or what he actually said, not what he meant to say, what he actually said, is that 80%, and he said he didn't have proven data, but from his experience, and this is a very seasoned practitioner. He taught law for many years. He was my lecturer as well at the Ghana School of Law. So he knows and president of the Ghana Bar Association.
Exactly.
He knows what he's talking about. What he said was that, in his opinion, in his estimation, 80% of cases at the Supreme Court, and I would want to narrow it down to even the other superior courts, particularly the High Court, are not won or lost on the merits of the case, but they are won or lost on procedural grounds. And so, you see, that is why a lot of the public do not perhaps understand the work of lawyers or the work of the justice delivery system. In practice, justice is not delivered based on emotions or necessarily what is true. It is what you can prove. And the laws that govern what you can prove are the laws of evidence and the laws of the rules of court, the procedure. So you have your substantive case, but how you would present it to the court and the kind of evidence you will lead will determine whether or not the court should even go to the merits of your case or not. And so a lot of litigants or people who seek access to the court would want to think that I have a right. Somebody bought my land and he did not pay. And so, or somebody took my money, he did not give it back. And so when I go to court, it's obvious the court should be able to order that I get my money. Yes, in the courts of morality, then you are right. But when it comes to court of law, there are rules and procedure that govern how you must present your case.
Right.
And I believe it is that context that the Supreme Court judge was speaking to.
So just to clarify, before I move on to Inusa, you're saying then, of course, procedurally, there are things that ought to be done. And sometimes based on that, you can lose a case or the merit of your case will be questioned and set aside simply because you didn't follow the right procedures. And I've heard many instances of saying, but what does that point to? Does that not point to the fact that maybe while law itself is why we call it a practice, because you continue learning even on the job, but how prepared are people then, the practitioners in the apex court to see through these cases? Because if you have merit per the law, but because of the procedural issues, your case is set aside or you lose, do you get what I'm saying? It means then that there are issues when it comes to the practitioners and how they present their cases. So where's the problem? Is it with the Supreme Court, or is it with the teaching, or is it with the practice? What is it?
Well, I don't think that we'll be able to pinpoint one cause. I think it's basically a matter of a human institution. We are all bound. I have had cases that have been dismissed on procedural grounds. You learn again, you refile, and you make sure you don't commit those same errors. And so I do not think it necessarily we will be able to pinpoint to one cause for it. I think that is why they say the life of the law is practice and experience. And so people have the opportunity to learn over and over and over again. And the more you do, the better you are placed to provide better quality service to your clients. And so what the Supreme Court, and he, for example, the judge was involved in a matter, a very famous matter, what lawyers commonly refer to as the NIB case, where a whole action was dismissed because the Supreme Court was the opinion that they didn't endorse the address and the full names of the parties to the writ. So a whole matter had gone to the Supreme Court, and only because of the absence of an address, it was struck out. Only that.
Right.
And so it's somebody sitting outside may say, oh, why should it be only because of an address? But the rules of courts are endorsed by the Constitution as part of the laws of Ghana.
Right.
And the courts are there to enforce the laws. So you cannot say that, well, why are you taking procedure or technicalities over substance? It behoves it's at the discretion of the judge. Some judges may say, in this instance, I think I'll let the substantive issue override the technical failures. It's solely at the discretion of the judge. But why would you go to court leaving the fate of your client in the hands of the discretion of the judge when you could have not, or you could have taken away that discretion by doing what is expected of you by the rules of court? Right. So lawyers always invest in the learning. We have lecturers like Justice ABDULAI, who continues to teach the law, so that we will learn the right thing and make sure that we don't fall foul of some of these technical or procedural requirements.
Important, crucial matters you've put up, but just hold for me. I did mention that I would move on to the former Member of Parliament for Tamale Central, but it appears we have Justice ABDULAI with us. Let me just check. Justice, good morning to you. Can you hear me?
Yes, indeed, I can hear you. Good morning, and good morning to Bobby, my very good friend. And I know he's always on my tails.
Great. Let me also just indulge or call for the indulgence of Inusa Hussaini. I did say I would come to you, but with your permission, I want to just take the initial thoughts of Justice and then come to you for your thoughts, sir.
There's nothing to worry about.
Thank you. Justice, were you surprised by the outcome? You've said that your expectations were not too high, but did you expect another 9-0 decision?
I expected, considering the amount of industry and investment that I had put into the review application, a positive feedback from the Supreme Court. So the well thought out.
You expected positive feedback?
Yes, from the Supreme Court. It was a well thought out application, which gave a lot more information, a lot of more authorities, and and the entire circumstances of this issue that confront us. I put everything before the Supreme Court. And so I really went in there with my hopes measured, taking into consideration the fact that the Supreme Court seldomly grant a review application. But I was really hoping that I'll get better than what transpired. But then again, that's the Supreme Court. Let's all remember, and I believe my good friend Bobby Wamson has once made this point, which is very instructive for all of us to remember, that it is the Supreme Court would never allow a review to be used as a medium to advance an appeal application, or sometimes to be used as a floodgate, to open a floodgate for review applications to be made. And these positions have been consistently hammered by the Supreme Court. And so sometimes, even where you have made a very good case, they will still throw you out, not because you have a bad case, but because they do not want to allow these two issues that I've just raised to be made. And they don't want to make it the everyday thing for everyone to simply just walk in and walk out.
Do you feel that is exactly what happened in this case? Do you feel that is what has happened in this specific case? They don't want to set a certain precedent. Do you feel that is it?
Because we do not have a reasoned decision, it's difficult to judge as to which of these grounds formed the basis of their judgment. Which of these policy grounds formed the basis for the decision they took. If you notice, it was a very short ruling. Simply to say that the application has no merit is difficult to state as to the extent to which it didn't have merit, or the basis for which you think that it has no merit. And so it doesn't give room for a lot of discussions.
Right. I get what you're saying. And of course, we await the ratio, the full decision or the reasoning. But I just want to find out, Justice. You talk about additional information and additional authorities that you put into this new case. So did it then come as a surprise to you that the court just swatted what you had brought and said, again, unanimously, that you have no merit?
Like I said earlier, I wasn't surprised at all, because as indicated, we all know how the Supreme Court deals with review applications. You can count the last time the Supreme Court granted a review application in this country. You can literally do a count. And the number of review applications that are granted, you can literally do a count of them. And if you get even 10 within the last maybe 10 years or thereabout, you even notice that majority of them would belong to the state from the Attorney General's office. And that's because of the difficulty and some of the impediments that are put in your place. In place just to avoid that happening. So that parties who are not happy with the Supreme Court would probably just use it as an avenue of an appeal or of a sort. And so I wasn't surprised at all. I wasn't surprised. Not because I didn't do a good work, as I indicated earlier, because I did a very thorough work, and that I strongly believe that but for some of these other considerations, if you have an open mind with this information before you, I think it will be very difficult for you to simply just ignore it. So
you're suggesting then that the court was not open-minded enough. It had its own, closed, thinking on this matter, and it wasn't willing to get out of that straitjacket. Is that what you're saying?
And that is partly to blame, because the court, as I've indicated, would want. In fact, if you read all the authorities, the Supreme Court re-emphasized the position that a review application is a very narrow route.
Right.
So that narrow route, for a person to be able to sail through, you need a lot. Clearly.
My final bit to you for now. In your statement of case, Justice ABDULAI, you added that there had been the discovery of, quote, new and important matters or evidence which, after the exercise of due diligence was not within the applicant's knowledge or could not be produced by him or you at the time when the earlier decision was given. I am curious, what new and important matter or evidence, and I'm sure Bobby is also curious because he said he hadn't read thoroughly what you had presented, what new or material evidence did you put forward that made you feel this review would be successful?
As a matter of fact, my review application dwelt largely on Order 45A, i.e. The fact that the original decision occasioned a miscarriage of justice on the basis that the exceptional circumstances. And this is what I largely dwelt on for the review application. And I said so because if you consider the antecedents that led us to the 1992 Constitution and the plethora of authorities in the 1992 Constitution itself to interpret the provisions that were originally the basis for the rate, you will come to that single conclusion that the original decision ought to be reviewed. I pointed out several ones. For instance, the position of the law, of the Constitution with regards to Article 295 to 297H and then 298. All these are and the Parliamentary Act of 1965, that's Act 300, particularly from Section 10, Section 13, 14. If you read all these acts and you put them together, it comes to one irresistible conclusion that an occupier of an office has the same authority as his deputies and his assistants at every point in time.
All right, it appears the connection to Justice ABDULAI has taken a bit of a dip. We'll get back to him to wrap on those comments as and when we get him. But let me come to Inusaf Hussaini, who has been patiently listening to the discussion thus far. Thank you so much, sir.
Thank you.
So receiving this verdict, a review, yes, and Justice says posterity will judge him fairly on this. But how did you appreciate the ruling of the Supreme Court?
Well, Evans, you recall that
this is Benjamin, actually.
Hello?
Yes, this is Benjamin.
Benji.
Right.
You recall that we had a Zoom discussion when the review application was filed by Justice ABDULAI. And I did indicate in the review application that even though the review raised interesting matters, my assessment of his chances was that it was going to be very difficult for the Supreme Court to review that decision, precisely because of the threshold, the legal threshold that you need to meet to be able to successfully invoke the jurisdiction of the Supreme Court to review his own decision. It's a very tall order. And even though Justice ABDULAI did demonstrate exceptional circumstances, he needed to also demonstrate that a combined assessment of the exceptional circumstances and its impact on the earlier decision will lead to a miscarriage of justice if the earlier decision is allowed to stand. And it was going to be a tall order. So it didn't come to me as a surprise at all that even though a lot of industry, like Justice ABDULAI have said, had gone into the application to the Supreme Court to review its own decision, that industry, unfortunately, did not meet by the Supreme Court standard the threshold for invoking the Supreme Court's jurisdiction for a review of the matter.
Right. But you heard Justice himself talk about the fact that he felt, on the basis of the additional information and the authorities he had cited, that the court would be of a different opinion. And listening to him, maybe not give another unanimous decision against him, but it was still 9-0. On the basis of that, do you feel that the court, as has been suggested by Justice ABDULAI himself, was in a bit of a box and unwilling to get out of that box or that straitjacket?
Benjamin, when you fail to successfully invoke the jurisdiction of a court, whether it's a lower court, an appellate court, or the Supreme Court, as in this case, the case doesn't stand on the merits of your argument. It doesn't stand on it. So if all the courts, if they put the checklist and they start checking the boxes, and you are unable to check any of the boxes, it really doesn't concern the justices of the Supreme Court whether your case has merit at all. But whether you have been able to invoke their jurisdiction is very important. It's not a norm for the consideration of a matter. You need to establish that the court had jurisdiction to look at the matter. And in the review jurisdiction of the court, you need to establish that threshold. So, if you are unable to establish that threshold, you are unable to establish that threshold. So a 9-0 decision would be it. It is not about the merits. It's about the jurisdiction.
Right.
Have you done it? Have you raised that jurisdiction? And the court was of the view that there was no enough demonstration of exceptional circumstances. And even that exceptional circumstances Justice ABDULAI was alluding to would not lead to a miscarriage of justice.
Now,
and that was why the case was dismissed.
Right. And so fundamentally you're in agreement that the case should have been dismissed.
Well, I'm just trying to explain. I have had discussions with Justice ABDULAI prior to his filing of the review. I'm just trying to explain. I also do not think that the initial decision of the Supreme Court is in line with the historical antecedent of the development of parliamentary jurisprudence in this country. I also do not think that. But I'm just saying that in this particular case, Justice ABDULAI needed, the application needed. He demonstrated, he tried. He did a comparative study of all the laws, of the practices in the West African sub-region as referred to by the Supreme Court in the Commonwealth countries. He tried to do cross-references, reading certain provisions of the Constitution together and demonstrating that read together those provisions could not could not lead to a decision the Supreme Court gave in the first instance. He cited the Parliamentary Act of 1965, Act 300, to show clearly. But all those provisions were available. They were available at the time the ordinary bench was sitting. They were available. They were not, they were not hidden. They were available. And so you needed to convince the court that these things were not available, but they were. They were available. And so that is why I'm saying that, yes. So when he did the combined region, and there are many, many issues. There are many issues. I drew his attention to one a particular one in the Interpretation Act and also in the Constitution where an enactment has been defined. The Supreme Court struck down Order 1093 or so. Is Order 109 is the standing orders an enactment within the definition of enactment in the Constitution or the Interpretation Act. So there are many issues, okay? But what the Supreme Court basically is saying is that all those issues could have been litigated when the matter came before them in the ordinary bench.
So tell me, as a former member of parliament for Tamale Central, you've been there, you've done that. What does this mean for our legislative processes moving forward now that it has been confirmed and reinforced by the Apex Court that deputy speakers can vote? What does it mean for us?
Well, I've argued, and I will continue to argue that way until the contrary is proven, that it will expose the speakership, and particularly when a deputy speaker is presiding, or any member of parliament presiding in the absence of the speaker and deputy speakers, will expose the speakership to petty partisan politics.
It will expose the speakership to petty partisan politics.
You will hear, because you see, and it will come into sharp focus under this present dispensation because of the numbers. Because of the numbers. And that is why I think that in the Fourth Republic, an attempt was made to insulate the speakership. And I agree with Justice ABDULAI when he says the speakership, the position of speaker, the authority, rights, and obligations of the speaker presiding attaches to anybody presiding at any time given. That's what the Constitution says, unless the contrary is proven. The contrary was not proven in the initial stages. That is, taking the law as existed, all of us read in Parliament accepted that a deputy speaker presiding shall not have the right to vote and shall not have the right to be counted for the purposes of establishing a quorum. But the law now is that a deputy speaker presiding or any member of parliament presiding shall have the right to count himself in or herself in for the purposes of determining a quorum and for the purposes of taking a decision. So that again, in the House we have a House that is almost equally divided between the majority and the minority. That will always open a deputy speaker presiding to accusations of bias. They will scrutinize his decisions, his pronouncements, his conduct while in the chair, and can lead to, for want of a better word, nasty situations on the floor of the House.
Do hold for me. Thank you for those initial thoughts. But let me also bring in Gary NIMAKO Mafo, who joins the conversation as well. Gary, thank you for connecting with us via phone.
Good morning, Benjamin. How are you?
I've been very well. Hope you are too.
Well, I'm fine. Good morning to Honorable Hussaini.
Good morning, Gary.
I couldn't listen to Justice ABDULAI, but I've had a bit of listening to at least a part of Honorable Hussaini's saying, and they are very erudite statements of the law. Now, let me make the point that the constitutional threshold, or even under the Courts Act, to be able to have the Supreme Court to overturn this earlier decision, that's the ordinary decision.
Right.
It must be very clear. Two main grounds. One, you must demonstrate that there is some error of law which has occasioned the miscarriage of justice by the ordinary panel.
Right.
And probably it might have maybe gotten new and evidence which were unavailable at the time when you argued the earlier application. Now, these are the prerequisite conditions to enable a court to entertain a review application. Now, if you are unable to meet these two minimum thresholds, the court will not even entertain application at all. I have had the benefit of going to the Supreme Court, review applications, and all of them have failed. Because they will tell you are seeking to use the review process as an appeal process. Review is not an appeal.
Right.
Review is review. So it is not an easy threshold to meet.
Right.
But what is it that we are discussing here? A deputy speaker of parliament, in my view, is not the speaker of parliament. The speaker of parliament is not elected upon. The Speaker of Parliament does not represent any constituency. And the Speaker of Parliament represents the constituency. And therefore, he has to get up to vote on any matter in Parliament. And I hold the humble view that the mere fact that the Deputy Speaker is presiding temporarily in the absence of the Speaker does not disable him from voting or does not make him a non-MP. You recall that Honorable Oduajaho had to be made Speaker of Parliament. He had to resign. He had to resign as a Member of Parliament before he was made the Speaker of Parliament. Because a Speaker of Parliament, in my view, is a referee. It's a referee who does not take part in the proceedings. So if you are a referee...
For those who have pointed out that I get the point you're making. Okay. They represent constituencies, and so they are elected members of Parliament. But right. For those who have also intimated that while they are in the seat, they are acting as speakers. You get it? They're playing the same roles you're speaking of. They are referees. And why should the referees be allowed to participate in the game?
You see, if you look at the 104 of the Constitution, it did not disentitle the Deputy Speaker, Member of Parliament presiding from voting. So why should the Supreme Court hold otherwise? It did not. And that is the reason why when the parliamentary standing orders 109 sought to preclude them from voting, the court had to strike it down as unconstitutional. You see, so for me, I think that where we are, this matter should be brought to a close. ABDULAI, well, he has done very well by going to the Supreme Court to seek clarity on this particular matter. And I think that is how every citizen ought to do. If something is happening and we are at the crossroads, we don't know exactly where the law stands, it's important that we go to Supreme Court for interpretation and an enforcement thereof. But that is the way I see it. That is the way I see it. I think the matter has been foreclosed. Deputy speakers, while they are sitting in the chair, obviously do not lose their right to vote. That is the position of the Supreme Court, and that is the law now, as we speak.
Okay. Is this a decision? And we'll be wrapping shortly on this belt and commencing with the Jatiquation question as well. But just to wrap on this and then give, Bobby Banson room to ventilate some thoughts after what Justice ABDULAI said. But for you, Gary, is this a decision that your side, the MPP, is willing to live by? Because who knows? We might have another hung parliament or a parliament that paints another picture that may not favor your party in this particular respect. Is it a decision your party is willing to live by?
You know, this is a decision that the party has no choice but to deal with it. That is why when we go to court and a decision is taken by the court, and you think that for some reason you want the court to take a second bite at it, you go for review. You know, now the Supreme Court has sat 9-0, it has come out that the constitutional threshold of even invoking a jurisdiction was not met. And so therefore, the application has been dismissed as unmeritorious. I think so be it. We all live by it as Ghanaians and make sure that we will make our action and inaction be guided by the decision of the court.
For you, Bobby Banson, to wrap the conversation, you had wanted to know what extra, as Justice ABDULAI spoke of, more information, more authorities and all of that. He has mentioned some of that to you. Does that strike you as something that could have swayed the courts in any way?
Ben, was that to me?
Yes, to you, Bobby Banson.
The line dropped, so if you could repeat your question.
So I was just asking, initially you were curious about what exactly Justice ABDULAI had added to his petition to give it merit. And he spoke about some of that, talking about more authorities and more information that he added. Though we do not have the precise reasoning of the court, does that strike you as something that could have given more merit to his case?
If I heard most of the things he said, he was making reference to mainly to laws that he thought that the Supreme Court did not, and I stand to be corrected, did not avert their minds to when they delivered their decision.
True.
So it's not like there were new facts. It was laws that the Supreme Court did not refer to those laws. They would have arrived at a different conclusion. I think it's fair. It's within every lawyer's right to have a shot at a review on those bases. That these laws existed at the time you delivered your decision, but your decision did not take those laws into consideration.
Okay. Justice,
you would have arrived at a... Yeah.
Do go ahead. There was a break in the connection. I thought you had landed. Do go ahead, Bobby.
Yes, sorry. No, and so, but I don't think that the judges would have arrived at a different conclusion as they did. So they think that even though they may not have specifically mentioned those laws, they think that interpreting them and applying them to the facts would have resulted at the same or in the same conclusion.